Thank you for joining me for this discussion about long-term disability, and I thought we would start by talking about what a long-term disability case is. And it's different than other injury cases. Other injury cases, you're suing because someone did something wrong and you've sustained injury as a result. Long-term disability cases start with the policy itself, the insurance policy. That's a contract of insurance that you've entered into either on your own behalf or your employer has done that for you to purchase disability benefits in the event that you're unable to work. So we have to look to the terms of the policy to find out what the restrictions are, what benefits you can get, whether they increase over time, whether there are different sorts of disability and other tests that are at play in the case as well. People are denied disability benefits for all sorts of reasons. People can be denied disability benefits because the insurance company feels you've taken too long to apply, or the insurance company feels that there's not enough evidence that's being provided to them, or insurance companies have sent your medical file to a doctor of their own choosing and paid that doctor to provide them with their thoughts on whether you're disabled, and it's possible that that doctor didn't agree, or you've been sent to one of the doctors that they've chosen and they've provided the insurance company with a report following their assessment of you and have determined that there are jobs that you can go back to. I want to stress, and I can't emphasize this enough, that if you feel that you're unable to work at this point in time, do not simply accept what the insurance company has told you. My personal opinion, and this is just me personally, is that over the years I've seen more and more denials of what I consider to be reasonable disability claims that ought to have been paid by the insurer. So that's something that I've seen over time, and you certainly should not just accept what the insurance company has done. It's important to understand the context of everything that's going on in your claim. You've got an insurance adjuster who is a salaried employee at the insurance company and who's being given instructions to review many, many cases, not just yours. And they are trying to sift through all of the information and come to decisions based on the information provided, based on what they're being told by the doctors that the insurance company has hired, and based on what they've heard from you. They are dealing with so many cases, and they are not trained medical doctors, that there is, in my opinion, room for error. And there often is error, in my opinion, in the cases that I am contacted about. So you should not simply accept it. What can you sue your insurer for? Typically, you can sue your insurer for the benefits that are payable under the policy. So for instance, if you have a long-term disability policy that for the first 2 years pays you if you're unable to go back to your own occupation, and beyond that, if you're unable to go back to any occupation and there's a set benefit amount or a benefit amount that is a percentage of your salary, then we calculate that and we figure out what amounts they should be paying you and go after them for that. Sometimes there are other benefits that could be payable under the policy or as a result of the policy as well. What usually happens in the case? Well, usually we will obtain a copy of their file. We will give you our thoughts with respect to that. We'll issue a claim against them often. There will then either be a discovery or a mediation. Discovery is the opportunity for both sides to ask each other questions about the denial and about ability to work, etc. We're able to get a complete copy of the file to see all of the adjusters, most of the adjusters' notes, and medical that they looked at, and medical opinions that they received, etc. The two options typically in these types of cases are either reinstatement or a settlement on a lump sum basis. Reinstatement means that they pay you what they owe you for past benefits, and then they put you back on claim where you continue to receive benefits. A lump sum settlement is where they basically pay you a lump sum amount of money as a full and final, and that's it. It's kind of like even more final than a divorce in Ontario, because they pay you a certain amount of money and that is it for all of your benefits entitlement in the past and in the future. And if you go to trial, typically you can only obtain past benefits and a reinstatement. You cannot obtain a lump sum into the future in most cases. Now, that is something that a lot of people don't understand. They think they can obtain a lump sum, and generally you cannot. You can just obtain a reinstatement. The preference in my experience is that most insurance companies prefer to try and obtain a lump sum settlement with you. So usually they've cut you off. They don't want to put you back on. They want to try and get to a lump sum settlement. And in certain circumstances, that is okay. But I've had a number of cases over the years where I've had to tell clients that I do not believe that to be reasonable in their circumstances. And that can be because of the severity of their disability. It can be because of how young they are and how long they're going to need benefits, and various other factors as well. And in those circumstances, I will tell a client that I don't believe that that's the best option for them. However, of course, the client is the boss, and if they decide they want that, that's a decision that they typically will make. But that's something to be aware of, that the insurance companies are going to probably want to try and lump sum settlement out the case because they don't want to deal with it on an ongoing basis. And to be fair, many people who are involved in these kind of cases as claimants don't want to deal with an insurance company that's already cut them off once either, because they don't trust them anymore. However, you have to take care of yourself, and you have to make sure that if you're young, if you've got a severe disability, that you're not just accepting a lump sum settlement on a wing and a prayer. You have to make sure that you've got a plan, that there's something realistic that's being put in place to protect you in the future. Some of the considerations that we often look at are taxation. If you have a taxable insurance policy, then of course, if you were paid benefits, then those benefits would have had tax deducted at source. And if you are suing a long-term disability carrier in those circumstances, you can claim for the past benefits, and with the past benefits, those would remain taxable. Oftentimes, the future benefits are not taxable depending on how the settlement is arrived at and the terms of the settlement and what's being claimed for. With respect to other considerations, there's CPP. CPP is something that you can apply for through the federal government, and there's old age security, of course, but beyond that, there's something called CPPD, which is Canada Pension Plan disability if you're unable to go back to work as a result of your injuries and disability, then you can claim for that as well. The long-term disability carriers will typically have a clause that will allow them to reduce your benefits and any settlement benefits for any amounts payable to you with CPPD. Pensions are another thing that can sometimes be looked at by the insurance company, as well as severance payments when they're calculating the benefit amounts you're entitled to. There's specific law with respect to that. And so it's important to be very careful on those issues. Insurance companies more recently have been often trying to enforce what are called clawbacks. So you're seeing insurance companies say, okay, well, we'll settle with you on a lump sum basis. We'll pay you 5 years or 3 years of benefits into the future. However, if you go back to any work in the next 2 years, we want some of our money back, and you got to tell us. So there are these kinds of clauses that are sometimes being requested. There are a whole whack of different clauses that are often being requested. So it's important to be cognizant of those and be prepared for them. I don't consider them to be legitimate clauses, but it's all part of the negotiation process, and important to discuss them, know that they could be coming from the other side. You can often also claim for something called punitive damages. Punitive damages are if there's an independent wrong. They did something really wrong as a result of in the case, and in those circumstances you can get additional money from them. However, the courts are very conservative in awarding punitive damages in Canada, and so those awards are not as often and not as large as what you'd hear about in the United States. But it's important to consider whether you're entitled to those sorts of damages. You typically have 2 years to sue after a denial of insurance benefits. I have in recent times heard some insurance companies argue that in certain group policies, you actually have to apply within 1 year, and there can be other time limits that can apply as well, and notice, etc. And so it's important to seek advice if you're having difficulties with your insurance company right away. So thank you very much for taking the time to listen. And if you have specific questions about your situation, I really do encourage you to speak with a lawyer to get independent advice.